course, joining us now, Christopher Greenlaw, professor at the University of Mississippi. Good morning, Professor. Good to see you again, sir.
Good morning. Good to see you.
Yes, sir. So we had this case decision handed down last week by the Supreme Court, I guess primarily, if not exclusively, pertaining to the state of Alabama in the way the state legislature drew its congressional districts. And they found that there was some gerrymandering going on. Says they're upholding, the Supreme Court did, a provision in the Voting Rights Act prohibiting racial gerrymandering. Is that about right, the way I described it there?
Well, sort of.
Okay.
So it's a Section 2 of the Voting Rights Act says you can't do things that result in an abridgment of the right to vote. It actually, to some extent, encourages an element of racial gerrymandering in that there's certain plaintiffs who say, hey, out of these 7 districts that the state has, we've had one majority African-American district. We could have 2. So the dissent that wanted to say, hey, they can just have one, they were actually the ones saying, hey, we shouldn't be having so much attention to race in how we draw these district lines. So there's an odd back and forth about charges of gerrymandering and kind of race consciousness. And the statute itself, I think, invites this kind of complication. It says anything that results in an abridgment violates the statute, but there's no entitlement to proportional representation. And the dissent made, I think, a pretty good point saying, well, how exactly are you going to figure out what this is if it's not a question of proportional representation? So if you look at other states, Louisiana, the governor said, hey, if you look at the number of Congress people we've got and the proportion of the African-American population, seems like we should have some more. That is actually kind of proportional type thinking. The statute says it doesn't give that. So it's an odd kind of odd statute with a whole bunch of odd precedent on top of it. And then, there were a 5-4 decision last spring about whether to let the districts go forward. And then a different 5-4 last week saying that they can't go forward. So the 2022 districts are not going to be the same as the 2024 in Alabama, and probably a bunch of other states. At least are going to try to make these claims fly there. So it could be 4, 5, 6 House seats at stake. Some people are saying, oh my goodness, if they had this decision back in 2022, it would have changed the composition of the House possibly. So it's every single House seat matters when you got a House divided as closely as it is. Of course, there's all kinds of things going to affect the 2024 election. Most importantly, who's going to be the candidates at the top of the ticket, because that always produces a huge effect in the congressional races as well.
So my understanding is the court said that when Alabama drew the districts, they did so such that one district had the majority of African-American voters in that district, and the rest were kind of dispersed in the other districts so that they really couldn't overcome, I guess, the white composition, the more Republican composition in those districts. And we should also indicate that Alabama has 7 members of Congress, right, of which 6 are Republican, 1 is Democrat. And if you looked at, to your point, Professor, this proportionate sort of districting, the composition of the state of Alabama is 67% white, 26% roughly African American. So if you do the math on that, it does come out to be 5+ districts would be sort of white represented. That's assuming that white voters in Alabama are more inclined to vote Republican. So how do they fix this? What's the outcome? What are they looking for as a cure?
Well, so I mean, basically what the Supreme Court has told lower courts to do are to use these 3 factors from this 1986 case, Jingles, and I mean, so the big question is, results in an abridgment. The big question that the court really didn't answer was compared to what?
Yeah.
And Alabama said, well, the thing you should be comparing it to would be what you would get if it were completely race neutral. If you just used a neutral districting criteria, and they said, look, if you take the computer programs that produce these districts and you say, I want to have traditional criteria of compactness and just different things you want to do, respecting county boundaries, that kind of thing. If you run 2 million simulations, none of them have 2 majority African American districts. And but the majority didn't really come up with an alternative. They just said, well, we're not going to use that because that would be contrary to what we've been doing for 35 years. But there's a lot of different things you could do other than having districts, really. So you could just say everybody in the state gets 1 vote, and then you just take the top, if you have 7 candidates, just take the top 7 people. So people all over the state could have affinity groups. Part of the idea of having districts is local interests get to combine together. So Oxford, we've got, we want to send somebody to Congress to the extent we can, who's just really obsessed with, the university and, the university interests. Alabama, they've got, of course, a Gulf Coast just like we do. And one of the arguments Alabama made, they said, well, we want to keep the coast together to kind of have a coastal congressperson to get, naval contracts and all that kind of stuff you're trying to get out of the feds. And the maps that had 2 majority African American districts, they would require the Gulf to be split up. And basically the court last week said, the fact that you want to keep the Gulf together isn't enough of a good reason to not to have a second majority black district. So, as with a lot of areas, you don't really have a lot of clear rules. You have a lot of, it's a multi-factor balancing test. I mean, actually, the statute itself says, what's a violation based on the totality of the circumstances. So you consider all these relevant factors, similar to what they've done in other occasions under Section 2. But it is, it gives the bad feeling to people who want clear rules. But there's a lot of things Congress could do if they, if they were inclined to come up with a compromise, which, there are some politically neutral compromises. Some of the no districting things are a little different from how we've usually done things. We traditionally have districts, but that has always invited gerrymandering of one kind or another.
Yeah. So is that legal, Professor?
Be able to pick their voters, you could just allow affinity groups from different ways. If you had at large with give everybody 1 vote, give everybody 7 votes, so you can allow give them some vote, but let them put more than 1 vote on 1 person, okay, and then just take the top out of that. Given that a lot of the elections are basically nationalized, there aren't as many local issues. I think there's something to be said for that kind of approach.
Is that's legal? I assume. I mean, I didn't even know that. So a state could just say, hey, we don't have districts. We just pick our reps based on the number we're allocated based on population.
No, states can't do that by themselves. So there's a federal statute that says how you can do it. So you might remember 20 years ago, we had the Branch versus Smith case when Mississippi lost a representative, and there's actually a statute saying if you lose a representative, then you have at-large elections. And what the Supreme Court said was, well, that only applies in an emergency where you can't have a court come in and redraw the districts. So historically, there haven't been a whole lot of at-large elections. They tend to be used, frankly, as a device for evading minority voting rights. So it doesn't have a great history. But if you did it, there are ways to do it, which would be quite respectful of minority voting rights. It would actually could be more respectful in the sense of encouraging, 1/5 of a state with 5 reps, or 1/4 of the folks in Mississippi, they could get together and elect somebody a little more radical maybe than the mainstream Republican Party would tend to put up. You could do the same kind of thing to preserve or promote minority racial minority voting rights. So there's just there's always a choice between how much centralization of the decision making you want to encourage and how much decentralization you want. And, when you get the political parties in charge of things in Congress as much as they are, they tend to be things that promote centralized decision making.
Professor, always appreciate your perspective and insight, sir. Good to talk to you. I'm sure we'll be talking some more about this and other stuff in the near future. Appreciate it.
Good to talk to you. More coming down the pike before too long.
Yes, sir. Professor Christopher Green, Ole Miss Law School, has been our guest here on Middays. We're taking a break. We're in the Element Wealth Studios, coming right back.